Hello, everyone. Welcome to another Lifetime Legacy Lawyer podcast. I'm your co-host, Thomas Vick, joined by my other co-host, Seth Wilson. Seth, how are you today?
Thomas, I'm doing great. It's good to be chatting with you on this Friday morning and talk about some interesting topics that showed up on your blog digest today.
Yes. So we had a couple of ones that, are kind of outside the norm, I guess, in the blog digest world. One of them was a way to kind of keep tabs on a parent's spending. So one concern that clients have in the elder law space is, you know, we want to maintain mom or dad's independence, but on the other hand, we want to kind of monitor that they're not getting taken advantage of. We don't want to, find out that mom or dad has gotten a phone call from some solicitation and has driven the car down to Walmart and bought a bunch of gift cards and sent them on to, who knows who it is. We don't want to see that happen. And so one way that you might be able to do that is through a prepaid card. And this is something that I had gotten sort of an advertisement for as an elder law attorney, but I think it's pretty neat. It's called the TrueLink Visa prepaid card, and the way that it works is you the child or power of attorney or trustee or whoever the person in charge of the funds is can put money on this prepaid card and then monitor the spending on it. So, uh, and can set limits on how much is being spent. And one of the things that's mentioned on the TrueLink website is, groceries are fine, but, buying gift cards for, whoever at Walmart, maybe not so fine. Um, and so it's a great way to do that. And I thought that was a piece of information that I wanted to get out there to my clients through the blog digest to just have another option for a way to keep track of a parent's spending. One of the issues is like they want to keep control of their bank account. Parents want to keep control of their bank account, and that comes with like the alternative of the child can't really see what's happening there, and so maybe this is a little bit of a compromise with that.
Yeah, and oftentimes we've run into that situation where maybe a child got added as a joint owner of a bank account for that very reason to make sure that they had access to the funds to move them around. And then when the person giving the access actually passes, that child ends up with complete ownership of an account, which may not have been the intended outcome. And so this seems like kind of a good way to balance both of those concerns and promote that independence as long as possible and freedom of, hey, here's your card and it's ready to go. And I know there's some of these that are similar for kids actually that you can tie to a child's account or fund it and those kind of things. And it seems like a really great concept for that, even in that situation where maybe you have a different trustee named in your documents than the guardian. The trustee may be able to give the guardian these types of prepaid limits and keep everybody moving forward without a lot of back and forth and that kind of pre-approved distributions, if you will, into that particular prepaid card. I noted in the article too, there was some app-based tracking and things that you could see with it as well, which seems to be very convenient.
Yes, absolutely. So I thought that was a helpful thing for folks to know about. Another topic in the blog digest today was what's so bad about canceling irrevocable trusts? Steph, I'm going to let you start the topic and I'll chime in on that one.
Well, it's irrevocable for a reason, right? We're trying to put something into that trust that doesn't get changed, and there's typically some bigger picture reason that that irrevocable trust was being created to either make an asset qualify later for some sort of advanced care or long-term care eligibility, or to protect the asset from being moved to someone that maybe wasn't supposed to go to, and those kind of things. So the big thing on irrevocable trust is what it does to the tax implications of whatever that asset is. It could expose that asset to unwanted and undesired tax implications, if you have to move it around, and sometimes you have to. But those are kind of the big ones that you think about, is really it kind of is a situation that will disrupt the ultimate distribution plan and could bring in unwanted tax implications to the plan.
Yeah, unwanted tax implications, and they're not that simple. I mean, maybe in some situations they are simple, but they're not simple. They come with some heavy consequences with them. For instance, with gift taxes. With an individual who sets up an irrevocable trust, maybe it's for estate tax purposes. They want to kind of discard themselves of some assets and kind of set that aside for estate tax purposes, and then you dismantle that trust and the assets are distributed. Well, have we lost capital gains? Stepped up basis. Have we lost stepped up basis to save taxes, or have we consequently caused a gift to take place? And as a result, gift taxes need to be filed, or at least gift tax returns need to be filed. Um, so it comes with those situations as well. In my world, Medicaid asset protection trusts are what I do quite a bit, and we want to have a way to sort of dismantle the trust or unwind the trust from time to time, because we may not make it to that 5-year look back period. And so there are some provisions that will allow the family to work together in order to make that happen. And there are consequences to doing that, and you got to be comfortable with those things, and be led by an elder law attorney or estate planning attorney through that. But you definitely want to make sure that if you're doing an irrevocable trust, that you feel comfortable with the ones that you have in charge and your beneficiaries, because if there's a day when you got to bring that asset back into your name, you've got to go through a trustee and beneficiaries in all likelihood to make it happen.
Yeah. And you've seen that. I see that a lot of times where potentially someone has put together a plan at a certain juncture in life where that made sense, and over time the irrevocable nature of that trust or the need to access whatever was placed into that change. So maybe somebody who had a house in the irrevocable trust in a different state, and then they moved, and now they're in a new state and they want to sell the house in the old state, and then they realize that the trustee didn't really agree with what they were trying to do. Now you've created a scenario where it's just going to be a little bit more challenging to work through. And like you said, with the provisions of the trust, if they have the opportunity to appoint an independent trustee or a trust protector, sometimes they can make adjustments as necessary, but largely the trust doesn't change, hence the irrevocable nature of that trust. And so those terms are locked in for a very specific purpose. So when you're kind of contemplating whether or not you're looking at an irrevocable trust or a revocable trust, those are really the big considerations, that flexibility and control, and or no, I'm kind of ready to move this asset out of my control regardless of what may happen to it in the future.
Yeah. And while we're on this topic, we could mention that here in Indiana in the last 4 or 5 years, a lot of changes have been made to the Indiana code so that adjustments can be made to trusts, and you're not completely dead in the water, so to speak, if a trust has a provision that just isn't working for the trustee or the beneficiary. One of those is trust decanting, where you're kind of closing down, terminating a trust, and then you are uh, putting the asset in a new trust that has similar terms, but you're able to kind of work around some of the administrative provisions of the trust that were you know hurting you or hindering you from doing whatever needed to be done with the trust. Trust decanting is a way to kind of deal with some administrative issues in a trust. And then there's also, a non-judicial settlement agreement for a trust. And that's where, beneficiaries can kind of agree. It's sort of similar to trust decanting, where you're able to kind of agree with all the trustees and the beneficiaries about what needs to happen with the trust. And it might be that it's wasteful or something like that,
Mm.
and you can kind of change how the trust operates. And so those are a couple options that estate planning attorneys can use to maybe not dismantle a trust, but kind of work around some issues that are present in a trust. And you may not even have to go to a court to get it done.
Yeah. And that's an interesting point, Thomas, because there are times where a trust will involve a court. And obviously, when we're doing probate avoidance planning, we're trying to stay away from the court. And so ultimately, the court does have the jurisdiction and the right and authority to interpret a trust if needed. But to the extent we can do things outside of that purview through the trustees and, like you say, an agreement through the beneficiaries that this is really what we wanted to have happen with this trust. And because of the way it's drafted or just some technical reason, we need to amend that provision. The idea is everybody could sign off on it and make that effectively what the trust says now moving forward without getting the court to actually review the trust and issue an opinion on what the judge or how the judge reads that. And so that's a very good tool. And I think Indiana largely has done a very nice job of recognizing these commonplace situations that really aren't contentious for folks, but provide additional flexibility in their planning and still the protections that they're looking for in their estate planning through trust documents and wills and things like transfer on death potentials. And the more we see from other states and how they work compared to what Indiana does, I think Indiana has done a nice job of making it a very good state to have your assets in, and obviously that's why a lot of people enjoy living here as well. So
Right, right. Yeah, it does make it, my experience in dealing with Indiana versus, a handful of instances where I've had to have an ancillary administration in a different state. Indiana is pretty convenient and pretty understandable, whereas, you've got a lot of different, old-timey rules, if you will, in other states that I shall not name at this moment.
yeah. Hey, we're only licensed in Indiana, or at least I'm only licensed in Indiana, so that's all I can comment on anyway. I always have
That's
to
right.
counsel with someone who is licensed in that jurisdiction, but for sure, something that gives you an appreciation for the rules that we have here on the probate and estate planning side of things here in Indiana. They've done a nice job of putting that all together and making as easy as we can for folks. So I always tell people when we meet, look, this is your law, right? You're a citizen of the state of Indiana, so you need to understand what you can do and then just make the decisions that make the most sense for you and your family and your beneficiaries.
For sure, for sure. Well, good stuff, Seth. Tell everybody how they can get in touch with you.
Thanks, Thomas. We are here in the heart of Hamilton County in Noblesville, Indiana, and that's the easiest way to find us is our website, noblesvilleattorney.com. How about you?
And my name is Thomas Vick. I'm the attorney at Vick Law in Greenwood, Indiana. And the best way to reach me is by going to vicklaw.org. Appreciate it, and we'll see everybody next time.
Thanks, Thomas.